Hello everyone, it's George from Ireland. So I'm now looking at adverse possession, one of my favourite topics in property law, squatters' rights. So how about in unregistered land? Well, after section 15.1 of the Land Act 1980, it said that no action can be brought for any person to recover land after the expiry of 12 years from the date on which the action accrued to him, that he could have taken the action against some person or against the person who claims it, i.e. a person who sold on the land. So after 12 years, it can be established, if you can establish continuous adverse possession of land, then it's yours. Now the period could be extended beyond 12 years due to incapacity, mental incapacity, or having been a child or something like that. The commencement of any period can be postponed in the case of fraud, the case of concealing your adverse possession, or mistake about the person trying to establish adverse rights in land. So the rules are quite simple. There are supervening events and there's successive disabilities. But the time that's begun to run is stopped. The time which has begun to run can be stopped either by the owner asserting his right or the right admitting a right of an adverse possessor, a signed acknowledgement in writing. So after a period of 12 years, the paper owner's title is extinguished and the squatter owns the land, as per section 17 of the Land Act 1980. So if someone is squatting in your property, in order to make sure they can't become the legal owner, give them permission. Because if you've given them permission, they're not squatting. Give them a license. You give them that for one day, I suppose, then rescind it, and then another 12 years has to run. You've got 12 years to get them out. So let's look at this accrual of right of action. So no right of action can accrue unless the land is in adverse possession. Though the date at which this accrual occurs varies depending on the kind of interest which the stranger is seeking to bar, as in the adverse possessor. The date on which an adverse possessor can start building up towards 12 years possession to claim a right in land is contingent on whether the person they've dispossessed is a freehold owner or a tenant, and whether or not the land is held on trust. So there are two factors needed to establish adverse possession. Number one, factual possession, and number two, intention to possess. So time runs against a person in present possession of the land from the moment the adverse possessor takes the land. So the moment that he or she moves there. But this can be discontinued, in which case the clock's got to start running from zero again. So discontinuance can be followed by a period of taking possession. But there cannot be a gap between periods of adverse possession. So possession of land is adverse if the land is possessed without the permission of the paper owner, without a license. The owner can stop possession from being adverse by giving the person an occupation license, like I said. And the squatter either accepts or rejects it. If they accept, but if they reject it, then that's not a license. So BP Properties against Buckler 1987. So neither a license nor a tenant at will can be an adverse possession because they're there with the owner's consent, and time will only begin to run in favour of the adverse possessor after the licensee or tenancy has been determined, i.e. ended. In J.A. Pye, Oxford, against Graham, 2002, this was found that it went to the House of Lords. Al-Rashid against Nasrullah, 2018. The Court of Appeal overruled the previous judgment in Partial and Hackney, 2013. It was decided there's nothing in the case of Pye to stop the possibility of registered proprietor being in adverse possession, falling within registered title, but also with another registered or unregistered title. Anyway, if a paper owner has been dispossessed by a chain of adverse possessor, the paper's owner's title will still be barred once 12 years has been built up between all those adverse possessors, provided the adverse possession was continuous, and it doesn't matter whether the subsequent squatters dispossessed the former adverse possessor or took possession with agreement. Each adverse possessor has a legal possessory title, and it can be defended against later squatters. It can be sold, it can be gifted, it can be passed on in death, just like a paper title can. It is vital to note that possession can begin with one squatter, and this time in possession can be added to the time in possession by another squatter. So Mount Carmel Investments Limited against Peter Thurlow Limited is a case. So after 12 years continuous adverse possession, the paper's owner's title is time barred. An adverse possessor who has consensually given his interest to a later squatter has no claim against their successor, but an adverse possessor has been dispossessed by a subsequent squatter has, just like a paper owner, 12 years in the dispossession to assert his claim against anyone else who has possessed the land later on. So what's possession? Now, there could be a discontinuance of possession where the owner of the piece of land, for which he doesn't need to use, leaves it and it's unoccupied, and a stranger then takes possession of it. So does this depend on whether the paper owner intends to use the land for a particular purpose? And how exact do we have to be about this purpose? And how firm is the intention? Is the stranger's knowledge or ignorance of this intention pertinent or not? It's all very tricky. So in Buckinghamshire County Council and Moran, it's clear that the land that had been acquired or retained by the paper owner for a particular purpose, there's no rule of law that he cannot be dispossessed by acts of trespass that are not inconsistent with that purpose. Moreover, the discontinuance of possession on the part of the paper owner, it must be demonstrated that the stranger had entered into possession. That means then possession in fact, and they intend to possess. The terms actual possession and factual possession are in reality mean the same thing. The courts tend to use them in different ways though. So factual possession suggests a degree of physical control, while trivial or occasional or equivocal acts do not prove possession. Much depends on the situation of each case, including the type of the land and the manner in which the land is usually used. So the fact of possession is accompanied by intention to possess on the part of the stranger, and the courts usually insist on unequivocal evidence of this intention, as well as the need for the stranger to demonstrate a clear intention so that the owner, if present at the land, would clearly appreciate this is not merely a persistent trespasser, but actually seeking to dispossess him. That's as per Powell and McFarlane, 1979. So usually the presence of an intention can be found by an implication of the evidence of the facts relied upon to establish control needed for a successful finding of factual possession, particularly where the evidence is unclear. There's no evidence the owner has an intention to the contrary, as per Pye, that's what Lord Hutton ruled. Therefore, the squatter's intention is assessed objectively. It doesn't usually depend on giving direct evidence of their subjective intention. It could be perceived through their self-serving or prove damage. For example, Bolton Metropolitan Borough Council against Musa Ali Kazmi, 1998. Evidence that could be pertinent, that where the acts of the users aren't clearly certain, that could give rise to a proof of intention. So Malik against Malik, 2019. In Pye, the House of Lords gave us a review of the pertinent cases about what means intention to possess, animus possidendi in Latin, and said that the squatter must demonstrate an intention to exclude the paper owner and the rest of the world from the land to the extent that that's practicable and as much as the law allows. So the intentions of the paper owner are not relevant here. In Pye, it was said to make no difference at all whether the adverse possessor had admitted that he would have paid for the land had he been asked to do so, because possession can be adverse until a request for payment is actually made. That's what Lord Brown Wilkinson said. It's not the intention to own, but the intention to possess that the courts are trying to find. You've got to bear in mind the facts of each case are vital in analysing whether or not the intention to possess is there. For instance, in Batt and Adams, 2001, fencing to keep animals in did not show an intention to exclude others. So that wasn't adverse possession. It's trying to keep the animals in, not other people out. So that wasn't enough. Treller and Newt, 1976, was a case which established the intention to possess. The motive of the fencing was not conclusive in itself, though. Hounslow London Borough Council against Minchinton, 1997, or Chambers against London Borough of Havering in 2011. So there are other cases to look at. There's Lambeth London Borough Council against Archangel, 2002, and here the Court of Appeal said that performance poet who acknowledged the local authority had title to land. It said that putting a padlock on the front door demonstrated possession. In Battersea Freehold and Leasehold Company Limited against Wandsworth London Borough Council, the occupier of a bombed-out pub allowed tenants to have keys to the site, and this was held that allowing access to others showed that he didn't have the intention to have exclusive control. In Simpson and Fergus, it was made clear that acts of exclusion of the paper owners are needed. A declaration of intention, even if it's clear, is not enough on its own. You have to possess it as well. Purbeck and Hackney London Borough Council, 2003, Judge Neuberger said that the claimant's contention that he'd been in adverse possession of a burnt-out shell of a building was not enough. So in Heaney and Kirkby, there was someone made a hard standing for parking beside the road, and there was gardening was going on. Topsoil was put there. There was also some flower bed planted. So occasional vehicular use by others was immaterial. It was still reasonable. Okay. In Thorpe and Frank 2019, the Court of Appeal found that by changing the level and repaving without enclosing a small triangular piece of forecourt to a semi-detached bungalow, the claimant had showed control, and that meant adverse possession. The land formed part of an open plan estate, and there were covenants about restricting fencing. In King and the Incumbent of the Benefice of Newburn and the Diocese of Newcastle 2019, the upper tribunal said title of a burial vault had not been acquired by adverse possession. The claimant had never entered or sought to exclude others. Locking the church doors was the only means of access to the vault was insufficient. There are also future interests and trusts of sale to be considered. The Land Act 1980 is very simple. Okay, there are other alternative periods available to a person entitled in remainder or reversion when the adverse possession is taken. So let's look at leaseholds now. It's quite easy to follow these rules of adverse possession to dispossess a tenant, but it's not quite so easy to gain good title against a landlord. If a stranger enters into adverse possession of land which is held on lease, time will run against the tenant from the moment, but it doesn't begin to run against the reversioner, i.e. the landlord, because the land would revert to the landlord when the tenancy is over, until the lease is expired. Bear in mind the tenants encroaches on adjoining land, there's a presumption they have done so for the benefit of the landlord. Smirk against Lindale Developments Limited 1975 is about that. How about the lapse of time? So when the expiry of the time limit happens, it doesn't operate as a parliamentary conveyance. That means it doesn't transfer the paper title's owner to the adverse possessor in unregistered land. It simply extinguishes the adverse possessor's title, i.e. Section 17 of the Limitation Act 1980. The adverse possessor gains legal estate in his own right. The adverse possessor is bound by any burdens that bind the land, such as restrictive covenants. But if the land is leasehold, then they're not liable for these covenants by the lease. So where they bar a tenant for years, that's a leaseholder, they're not in the same situation as the signee of the lease and can't be sued for the expiry of the lease or breaches of the covenant that occurred while he was in possession of the land. But they might be forced during the term of the lease to carry out acts of covenants through threat of forfeiture. The freeholder can kick out the adverse possessor once the lease is over. So the tenant has surrendered the tenancy to the freeholder, and the freeholder then kicks out the squatter. Fairweather against St Marylebone Property Company Limited 1963, or Tichburn against Weir 1891-94, or Taylor against Twin Barrow 1930. So there's permissive occupation, there's payment, there's acknowledgement. So the acts carried out with permission of the paper owner that don't exclude them from the land, and therefore they cannot contribute to the adverse possession claim. But even when that permission is an informal license, an implied license, but it must be borne in mind the license will be implied automatically if the owner contemplates a future use that's compatible with that of the squatter. But this was called a heresy by some in Lee against Jack. It was abolished by paragraph 8.4 Schedule 1 of the Land Act 1980, if you look at the case called Pye. And that doesn't exclude the potential for the application of a license if the specific acts justify it, like Colin Dawson Windows Limited against Kings Lynn and West Norfolk Borough Council. By permitting the claimant to go into possession during negotiations to purchase land, there are a few cases of successful defence by paper owners due to an implied license. Payment for land is admitting the recipient has rights over land, and by ceasing to make payments, that could start adverse possession. Acknowledging the paper's title's owner in another way can prevent adverse possession, but only by the acknowledger and his successors, but only if they are in writing.